What is the attitude of the court to an agreement where the mortgage is expressed to be redeemable for a term certain? This is a negation of the right of the mortgagor to redeem his property at any time he is ready with the principal sum and interest already accrued. Thus, the court frown at this restriction. However, it may be allowed, putting into consideration the following conditions. A. What is the length of time? Where the length of time is short, the court may allow it. Where it is fairly long, the court may not allow it. B. Who are the parties? If the mortgagor is a corporate body made up of members who are elite and knowledgeable, the court will allow the restriction on the ground that the members ought to know the implications of such restrictions. Where, however, it is an individual, the court may be sympathetic towards him. C. What type of mortgage is created? D. What are the circumstances surrounding the creation of the mortgage? In the case of multi-service banking and merged in 1979 CH 84, a restriction of redemption for a period of 10 years was held to be too long. Information required for the creation of a deed of mortgage are 1. Particulars of the parties that must include their full names and addresses. 2. Date of commencement. 3. Duration of the mortgage. 4. The principal sum of the mortgage. 5. Interest rate. 6. Description of the mortgaged property. 7. The various covenants agreed to be inserted into the mortgage agreement. 8. The witnesses to the mortgage transaction. Upstamping. Upstamping on mortgages refers to the practice or process of payment of additional stamp duties on a mortgage document in satisfaction of the increased facility granted over an earlier mortgage. This is seen to exist where a mortgagor had earlier borrowed money from a mortgagee using a particular property as security for the loan and subsequently wants additional loan from the same mortgagee using the same property as security. What will be required in this instance is that the mortgagee will draft a new agreement and the document will be upstamped. Simply put, upstamping is the act of paying additional stamp duty on the new mortgage or loan agreement. Features of upstamping: 1. The property must be the same. 2. The parties as well must be the same. 3. The new facility is different. 4. Additional stamp duty is paid on the new facility. Very important, the consent of the governor is not required in granting a new facility so long as his consent had earlier been obtained when the first mortgage was created. Bank of the North and Babatunde, 2011, 12 SC Part V at page 1. To this effect, consent of the governor is required for an alienation of interest in land, but not for any additional facility. Only Boys Technical Services Limited and Union Bank of Nigeria PLC, 2003, 15 Nigerian Regular Report, Part 844 at page 545. Remedies of the mortgagee. Remedies are cumulative and not necessarily alternative. Olori Motors Limited and Union Bank PLC, 2006, 10 Nigerian Regular Report, Part 989 at page 586. The mortgagee has the option of taking any of the remedies of his choice amongst all the remedies available to him. However, the particular remedy taken will depend on the following. A. What the mortgagee is claiming. Is the mortgagee claiming the principal or the interest? B. What is the type of mortgage? Is the mortgage legal or equitable? The rights and remedies include the following. 1. Right to take possession of the property. A legal mortgagee has the right to take possession of the mortgage property upon execution of the mortgage deed. This right is immediate and not contingent upon default of the payment of the mortgage sum. Section 19 sub 1 4 of the Conveyancing Act, Section 123 of the Property and Conveyancing Law. This power extends to the right of the mortgagee while in possession to cut and sell timber and other trees ripe for cutting. The mortgagee who takes possession is bound to account strictly to the mortgagor for his actions while in possession. 2. Appointment of a receiver. A receiver is an independent and uninterested party appointed to manage the mortgaged property, having rival claimants. In Adetona and another and Zen International Bank Limited, 2011, JLR 43666 SC. The court defined the receiver as a person appointed by the court for the purpose of preserving the property of a debtor pending an action against him, or applying the property in satisfaction of a creditor's claim whenever there is danger that, in the absence of such appointments, the property will be lost, removed, or injured. Powers, duties, and rights of a receiver. Section 24 of the Conveyancing Act, Section 131 of the Property and Conveyancing Law. A. The receiver shall have the power to demand and recover all the income of the property of which is appointed a receiver. B. Shall be entitled to remuneration out of the money received by him to pay taxes, rates, and other outgoings in respect of the property. C. To pay interest accruing in respect of any principal money due under the mortgage. D. To pay the residue of the money received by him to the person who is entitled to receive the income of the mortgaged property. Very important, a receiver must act in good faith. Where he colludes with the person to sell the property at the gross undervalue, the sale will be set aside. 3. Action in court to recover principal and interest. The mortgagee can institute an action in court against the mortgagor to claim the principal sum advanced to the mortgagee and the interest that has accrued on it. This can be done by way of summary judgment or judgment under the undefended list. 4. Action for an order of specific performance. This remedy is available to an equitable mortgagee. This would usually arise where the equitable mortgagor fails, refuses, neglects to complete the documentation of the mortgage agreement. The court will give an order mandating the mortgagor to complete the documentation. Thus, the legal interest in the property will be passed to the mortgagee so he can exercise his power of sale. Very important, the equitable mortgagee has no legal estate to transfer and as such he cannot exercise the power of sale. Hence, an action for specific performance. Where the mortgagor refuses, fails or neglects to complete the documentation, the court will then order an officer of the court to execute a legal mortgage upon which the mortgagee can act. 5. Part performance. Part performance on the part of the mortgagee is the actual handing over of the loan to the mortgagor. On the mortgagor's part, the part performance is the deposit of his title deed to the mortgagee coupled with his intention to create a legal mortgage. Ogundiani and Araba, 1978, 11, NSCC 334. Quick glance note is powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Connie Close of Idemai Crescent, Igwefon, Lekki, Lagos, Nigeria. Tell WhatsApp 081-427-5425, 091-526-91367, and send your emails to rolumsandluxury@gmail.com, Instagram rolumsandluxury, Facebook rolumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 091-259-21620 or send an email to resistandpartners.chambers@gmail.com.